After Bruen, after the Supreme Court explicitly told state governments that you cannot treat the Second Amendment like a second-class right, how many places do you think the government can still ban you from carrying a firearm? Just schools and courthouses like everyone assumed? Or almost everywhere you actually go in daily life? Because a federal appeals court just handed down a decision that guts your right to carry in parks, transit systems, forests, demonstrations, bars, museums, stadiums, healthcare facilities, and more, and they did it by claiming they're just following Bruen's history and tradition test. The Fourth Circuit Court of Appeals just addressed Maryland's sweeping gun-free zone law, and while they struck down one piece of it, they upheld almost everything else, creating a roadmap that blue states across America are going to copy immediately. This is one of the most important sensitive places rulings since Bruen came down in 2022, and if you carry a firearm or plan to carry one, this decision is going to affect your life whether you live in Maryland or not. Before I break down exactly what the court approved and why it's far worse than most people realize, I need you to understand something. Your Second Amendment rights are being systematically destroyed right now through judicial rulings that most gun owners will never even hear about. Subscribe to this channel immediately. Hit that like button. Drop a comment telling me what state you're in and whether you've noticed carry rights being restricted in your area, because this is the only place you're going to get the unfiltered truth about how courts are rewriting the Constitution while claiming to follow it. This case is actually multiple lawsuits combined into one, and you need to understand who's fighting on each side because it tells you everything about what's really at stake here. On one side, you have everyday Maryland gun owners, regular people who just want to exercise their constitutional right to carry a firearm for self-defense. You have Maryland Shall Issue, a state-level gun rights organization that's been fighting these battles for years. You have the Second Amendment Foundation and Firearms Policy Coalition, two national organizations that actually litigate these cases instead of just sending fundraising emails. These are the plaintiffs, the good guys, the people standing up for constitutional rights. On the other side, you have the state of Maryland, but they're not fighting alone. They're backed by Everytown for Gun Safety, the Bloomberg-funded gun control machine. They're backed by the Brady campaign. They're backed by Giffords Law Center. And they're backed by a coalition of blue states, including California, New York, Massachusetts, Illinois, and others who filed friend-of-the-court briefs supporting Maryland's restrictions because they all want the same roadmap for gutting the Second Amendment in their own states. The core issue in this case is Maryland's post-Bruen response law. The legislation they passed after the Supreme Court told them they couldn't deny carry permits to regular people anymore. Maryland's response wasn't to respect the Constitution. Their response was to say, fine, we'll issue the permits, but we're going to ban firearms in nearly every single public space by labeling them all as sensitive places. It's the same playbook we've seen in New York, New Jersey, California, and other states that treat the Second Amendment like a suggestion rather than a constitutional mandate. The plaintiffs argued, correctly, that this was an obvious end run around Bruen, an attempt to nullify the Supreme Court's decision by making it legal to have a carry permit, but illegal to actually carry anywhere that matters. And here's the critical part that should terrify anyone who cares about constitutional rights. The Fourth Circuit mostly agreed with the plaintiffs' characterization of what Maryland was doing, but then they upheld most of it anyway. They admitted Maryland was trying to gut the right to carry, and then they said that's fine, you can do that as long as you call it a sensitive place and point to some historical analogy from the 1800s. The Fourth Circuit formally adopted what they call a two-step Bruen analysis specifically for sensitive places, and I want to be very clear about something. The Supreme Court did not tell courts to do this. This is the Fourth Circuit creating its own framework and claiming it's what Bruen requires. Step 1 of their test asks whether the right to carry firearms in public is protected by the Second Amendment, and the answer is obviously yes, because Bruen already decided that. But step 2 is where the trapdoor opens. The government can still restrict carry if it proves a historical tradition of banning arms in similar locations. And here's the absolutely key takeaway that you need to burn into your memory. Sensitive places are not decided at the text stage of Second Amendment analysis. They're decided at the history and tradition stage. And that distinction gave the state of Maryland and every other gun control state an enormous amount of room to maneuver. Because once you're arguing about history instead of arguing about the text of the Constitution, judges can cherry-pick whatever historical analogies they want to support the outcome they've already decided they want. You can always find some example from colonial America or the post-Civil War era or the Wild West where somebody somewhere banned guns in some location for some reason, and then courts can claim that's proof of a historical tradition even when it's nothing of the kind. Let me walk you through what the Fourth Circuit actually approved, category by category, because you need to know exactly where you can and cannot carry under this ruling. And you need to understand that what happens in Maryland doesn't stay in Maryland. This becomes precedent that other courts will cite and other states will copy. Category number 1 is government buildings, and there's no surprise here. Courts, state offices, legislative buildings, government administrative facilities, constitutional bans on firearms in those locations were upheld. The court relied on Heller and Bruen for that principle. And most gun rights advocates accept that government buildings where official business is conducted can be gun-free zones. That's not the controversial part. Category number 2 is public transportation. And this one is massive because this is where you see the court's willingness to stretch historical analogies beyond any reasonable limit. The Fourth Circuit upheld a complete ban on firearms on buses, subways, light rail systems, and commuter trains. Total prohibition. You cannot carry on public transit in Maryland according to this ruling. Why? Because the court said when Maryland runs a transit system, the state is acting as a property owner, not as a regulator. They're not regulating your behavior on their property, they're setting rules for their own property just like a private business could. And then the court leaned heavily on 19th century railroad regulations where private railroad companies prohibited loaded or accessible firearms on their trains. Let me point out the absurdity of this reasoning. Private companies in the 1800s setting safety rules for their own private property is now being used to justify government bans on public transportation that's funded by taxpayer money and operated as a government service. The railroad analogy is completely inapplicable because those were private companies making private property decisions, whereas public transit is a government service that citizens are forced to fund through their taxes. But the Fourth Circuit didn't care about that distinction. The bottom line is, if a state runs a transit system, the Fourth Circuit says guns can be banned entirely, which means if you rely on public transportation to get to work or to travel around the city, your Second Amendment rights effectively don't exist because you can't carry the one place you actually spend time. Category number 3 is school grounds, and this goes far beyond what most people think. Not just inside school buildings, which have always been recognized as sensitive, but the entire school grounds, including pickup and drop-off areas, athletic fields, parking lots, and open spaces. The court ruled that these areas are functionally identical to schools themselves and therefore sensitive. So if you're a parent picking up your child from school and you have a valid carry permit, you have to disarm before you enter the school property line, which might be hundreds of yards from the actual building. Category number 4 is the most dangerous precedent in this entire ruling, and it's the one that should scare you the most because of how easily it can be abused. If a public demonstration is happening anywhere, and a police officer notifies you that you're within the restricted zone, you must leave the area immediately or disarm. The restricted zone extends 1,000 feet from the demonstration. Let me say that again. 1,000 feet. That's more than 3 football fields in every direction. The court justified this by tying the Second Amendment to the First Amendment's requirement that assemblies be peaceful. The translation is simple. If the government decides that your presence with a firearm threatens public peace, they can force you to leave or disarm. Do you see the problem here? This gives police officers on the ground complete discretion to decide whether your carrying a firearm is a threat to a peaceful assembly. It doesn't matter if you're not part of the demonstration. It doesn't matter if you're just walking down the street going about your business. If there's a demonstration happening somewhere within 1,000 feet of you, and a cop decides your gun makes him nervous, you're breaking the law. This is going to be abused, guaranteed. Political protests in cities are going to create massive gun-free zones that encompass entire downtown areas, and anyone carrying a firearm will be subject to immediate arrest. And if you're starting to realize just how comprehensive and systematic this attack on the Second Amendment actually is, then do this right now. Subscribe to this channel, turn on notifications, share this video with every gun owner you know, because the mainstream media is not covering this, and gun owners need to understand what's happening before it's too late to fight back effectively. Category number 5 is state parks and forests. And yes, you read that correctly. Even forests. The Fourth Circuit said that modern public parks didn't exist in 1791 in the form we know them today. So they looked to post-Civil War history where some cities banned firearms in newly created public parks. Bruen explicitly said not to do this kind of analysis. Bruen said you can't just pick any historical analogy you want from any time period. You're supposed to look at the founding era, or at most the Reconstruction era, for evidence of historical tradition. But the Fourth Circuit ignored that and found some examples of park gun bans from the late 1800s, and then they extended that logic to state forests by claiming that forests now function as recreational and educational spaces similar to parks. Hunting exemptions remain in place because even these courts know they can't ban hunting in forests without causing a political firestorm. But general carry in state forests is now banned under this ruling. You can carry a rifle for hunting during hunting season with proper licenses, but you cannot carry a handgun for self-defense while hiking in a Maryland state forest. Category number 6 is healthcare facilities, and this is another sweeping prohibition. Hospitals, clinics, rehabilitation facilities, mental health facilities, all gun-free zones under this ruling. The justification is protecting vulnerable populations and some strained historical analogy to bans on firearms in scientific or medical environments from centuries ago. Never mind that hospitals are exactly the kind of places where violent incidents happen, where domestic abusers show up looking for victims, where people are vulnerable and might need to defend themselves. The court decided that healthcare facilities are sensitive, period. Category number 7 covers stadiums, museums, casinos, and amusement parks, all upheld as constitutional gun-free zones. The court relied on historical examples of weapons bans at ballrooms, fairs, and social gatherings from the 1800s. They said even museums qualify as sensitive places because they are crowded public spaces, often frequented by children. Think about what's happening here. Museums are educational institutions where adults take their families to learn about history, science, and culture. They're not inherently dangerous places. They're not places where violence typically occurs. But because children might be present, and because the court could find some historical example of weapons being restricted at public gatherings, museums are now gun-free zones. This is outcome-driven reasoning. The court decided they wanted museums to be gun-free, and then they worked backward to find a historical justification for it. Category number 8 is bars and locations that serve alcohol, which is another major restriction with huge real-world implications. Any location that sells alcohol for on-site consumption is now a constitutional gun-free zone under this Fourth Circuit ruling. The court leaned on colonial-era laws that regulated firearms and alcohol, including laws that barred militia members from drinking while armed. But here's the problem with that analogy. Those historical laws were about preventing intoxicated people from being armed. They were about the combination of drinking and carrying. They were not blanket bans on firearms in any establishment that happens to serve alcohol. Modern carry laws already prohibit carrying while intoxicated. That's not what this is about. This is about banning all carrying in restaurants that serve wine with dinner, in sports bars where you might watch a game and have a beer, in any establishment with a liquor license, even if you're not drinking at all. Here's the one bright spot in this entire ruling, and it's important, even though it doesn't offset the massive damage done everywhere else. Maryland tried to flip private property rights completely on their head with a presumption rule similar to what New York tried to do. Their law presumed that all private property open to the public was gun-free unless the property owner explicitly posted signage allowing firearms. This is the opposite of how property rights have always worked in America. Normally, your property is open to people carrying firearms unless you specifically prohibit it. You have to post a no-gun sign or verbally tell people they can't carry on your property. Maryland tried to reverse that. They wanted to make every single private business a gun-free zone by default, and gun owners would only be allowed to carry if the business posted a sign saying guns are welcome. The Fourth Circuit struck that presumption down. They said this violates historical property rights traditions because historically, the burden was always on property owners to prohibit firearms if they didn't want them on their property, not on citizens to assume prohibition by default. That portion of Maryland's law was ruled unconstitutional, and that's a genuine win. But let's be very blunt about what just happened in the bigger picture. The Fourth Circuit striking down the private property presumption does not change the fact that they just approved a massive, comprehensive roadmap for blue states to label vast areas of public life as sensitive places, to rely on strained and cherry-picked historical analogies to justify those designations, and to effectively shrink the right to carry down to sidewalks and streets and maybe your own home. This ruling will absolutely be cited immediately in New York, New Jersey, California, Massachusetts, Hawaii, and every other state that's trying to nullify Bruen through sensitive place designations. Those states are watching Maryland cases closely, and when a federal circuit court says you can ban guns on all public transit, in all parks and forests, near all demonstrations within a 1,000-foot radius, in all healthcare facilities, in all bars and restaurants that serve alcohol, in all museums and stadiums, they're going to copy that model word for word. And here's the terrifying question at the heart of all of this. If sensitive places can be defined to mean anywhere significant numbers of people gather, if courts are willing to accept any historical analogy, no matter how strained or inapplicable it might be, then where exactly does the right to bear arms exist in practice? The Supreme Court said in Bruen that you have a right to carry a handgun in public for self-defense. But if you can't carry on public transportation, and you can't carry in parks, and you can't carry near any demonstration or protest, and you can't carry in any government building, and you can't carry at schools or near schools, and you can't carry in hospitals or museums or stadiums or anywhere alcohol is served, and you can't carry in forests except during hunting season, then what's left? Sidewalks, residential streets, your car maybe, unless you need to park near a school or a protest, your home, unless you live in an apartment building that the state decides is a sensitive place because it's a multi-family dwelling. This is absolutely Supreme Court material. This case screams out for Supreme Court review because if the Fourth Circuit's interpretation of sensitive places is allowed to stand, then Bruen means nothing. The right to carry in public for self-defense becomes theoretical rather than practical. It exists on paper, but nowhere in the real world. But will the Supreme Court take this case? That's the question that should keep you up at night because the Supreme Court declines to hear most cases that are appealed to them. They only take a small percentage of cases, usually ones that create clear circuit splits where different parts of the country have contradictory rules, or cases that present questions of exceptional national importance. This case might meet those criteria. Different circuits are reaching different conclusions about what counts as a sensitive place and what kind of historical evidence is sufficient to justify modern restrictions. But there's no guarantee the Supreme Court will step in, and even if they do, it could take years for this case to work its way up through the system, get petitioned to the Supreme Court, get accepted for review, get briefed and argued, and finally decided. In the meantime, gun owners in Maryland and across the Fourth Circuit are living under these restrictions right now. Their carry rights have been gutted, their Second Amendment has been reduced to a narrow corridor of permissible exercise that doesn't include most of the places they actually go in daily life. And this is exactly why staying informed about these court decisions matters more than almost anything else you can do as a gun owner. You can have the best firearms training in the world. You can have the most expensive carry gun money can buy. You can have a valid carry permit that you worked hard to obtain. But if you don't know where you're legally allowed to carry, if you don't understand how courts are interpreting sensitive places, if you don't follow the legal battles that are literally determining whether your rights survive or get nullified, then you're walking blind into situations that could turn you from a law-abiding citizen into a criminal defendant facing felony charges. This is also why supporting the organizations that are actually litigating these cases matters so much. The Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, state-level groups like Maryland Shall Issue. These organizations are in courtrooms fighting these battles every single day. They're the ones filing the lawsuits, making the legal arguments, appealing the bad decisions, and trying to get cases in front of the Supreme Court that might actually restore the Second Amendment to its proper scope. They can't do that work without funding. They can't hire the lawyers and pay the court costs and file the appeals without support from gun owners who understand what's at stake. If you care about the Second Amendment as more than just a talking point, if you actually want to preserve the right to carry for yourself and for future generations, then you need to support the groups doing the real work. And this is why understanding that Bruen was only the beginning of this fight, not the end, is so critically important. A lot of gun owners celebrated when Bruen came down in 2022. They thought the Supreme Court had settled the question. They thought carry rights were finally secure. They thought states would have to respect the Constitution. But what actually happened is that Bruen shifted the battlefield. It changed the legal framework. It gave gun rights advocates better tools to fight with. But it didn't end the fight, and it didn't prevent states from finding new ways to restrict rights within the new framework. States like Maryland looked at Bruen and said, okay, we can't deny permits based on proper cause anymore, so we'll just ban carrying in so many places that having a permit becomes meaningless. And courts like the Fourth Circuit looked at Bruen's history and tradition test and said, okay, we'll just stretch historical analogies until we can justify almost any restriction the state wants to impose. This is the reality of constitutional litigation. Every victory creates new battles. Every Supreme Court decision gets interpreted and applied by lower courts, and those lower courts don't always interpret it the way the Supreme Court intended. Rights that seem settled can erode quickly if people aren't paying attention and fighting back through the legal system and the political process. If you found this breakdown valuable, if you're starting to understand how your carry rights are being systematically destroyed through judicial rulings that most people never hear about, then you need to do 3 things right now. First, subscribe to this channel and turn on notifications so you don't miss the next legal update that could affect your rights and your freedom. Second, share this video with every gun owner you know, every person who carries or wants to carry, every American who cares about the Constitution, because these court decisions don't stay in Maryland. They spread like a virus to every blue state in the country, and eventually they affect gun owners everywhere. Third, leave a comment telling me what aspect of this ruling concerns you most, what you think should happen next, whether you've experienced sensitive place restrictions in your own state, because I need to know that this information is reaching the people who need it and that gun owners are waking up to what's happening before it's too late to fight back effectively. The Fourth Circuit just handed anti-gun states a roadmap to nullify Bruen. They just showed every gun control advocate in America exactly how to ban firearms in almost every public place while claiming to follow the Supreme Court's guidance. And they did it by manipulating history, stretching analogies, and applying a 2-step test that the Supreme Court never told them to create. Your Second Amendment rights are not permissions granted by the government. They're not privileges that officials can give or take away based on their policy preferences. They're inherent rights that existed before the Constitution was written, rights that the Second Amendment protects from government infringement, rights that shall not be infringed according to the clear text of the Constitution itself. But rights that aren't defended become rights that are lost. Rights that people don't fight for become rights that disappear one court case at a time, one regulation at a time, one sensitive place designation at a time, until what remains is so narrow and so restricted that it barely resembles a right at all. That's what's happening right now in 2026. That's the fight we're in. That's why every single one of these court decisions matters. The Fourth Circuit ruling on Maryland's sensitive places law is not just about Maryland. It's about whether the right to bear arms will exist in any meaningful form in blue states across America. It's about whether courts will honestly apply the Constitution or whether they'll manipulate history to reach predetermined outcomes. It's about whether Americans will accept having their rights reduced to a narrow corridor of permissible exercise, or whether they'll demand that the Constitution means what it says. Stay armed, stay informed, stay engaged in this fight. Support the organizations doing the litigation work, make your voice heard in the political process, and never ever accept the premise that your constitutional rights exist only where the government decides to allow them. Because that's not how America is supposed to work, and it's not how the Second Amendment was written, and it's not what shall not be infringed means, no matter how many federal judges pretend otherwise.